Justice cannot thrive where and when falsehood is practiced. In Indira Gandhi versus Rajnaran, this court emphasized that judicial review and fair elections were a fundamental part of the Constitution. My esteemed brother and sister judges, Sri R. Venkataramani, Learned Attorney General of India, Sri Tushar Mehta, Learned Solicitor General of India, Sri Kapil Sibal, President Supreme Court Bar Association, Sri Vipin Nair, President Supreme Court Advocates and Record Association, members of the Bar and the registry officials. As we gather today to commemorate the 75th anniversary of first sitting of the Supreme Court of India, we stand on each historic occasion at an intersection that connects the history, the present, and the future. What began in 1950 as a successor to the Federal Court has evolved into perhaps the world's most vibrant and dynamic apex court that truly embodies the aspirations and diversity of 1.4 billion people. What sets the Supreme Court apart from the global stage is its unique character as a true people's court. The court remains accessible to common public, and in its diversity, the judges in the courtroom, the multitude of voices finds representation at the highest level of our judiciary. Each decade of our court's jurisprudence serves as a mirror of the nation's challenges. The rings of a mature tree that reflects its journey through different seasons, these judgments reflect not just the legal evolution, but our country's very pulse. What emerges is an unmoving structure carved in a sandstone, but rather a living and breathing institution. It has been responsive to the conscience of a democracy, adapting and evolving to embrace the complexities of each era while remaining rooted in the bedrock of constitutional values. The first decade, 1950, the sunrise years. In 1950, when we adopted the Constitution, the three wings of the government were assigned distinctive responsibilities. The monumental task was to transform a newly independent nation into embodying the values, the ethos, and morality of our Constitution. In Dr. B.R. Ambedkar's words, constitutional morality has to be embodied in nation building. It has to be cultured in a nation like India, where everything is newborn. To achieve this ideal, the Constitution bequeathed to the Supreme Court of India a wide and expensive jurisdiction. In its inaugural sitting, the first Chief Justice of India, Justice Kania, had said, Supreme Court will decide and interpret the laws of the land, but not in the spirit of formal and barren legalism. One of the court's earliest decisions, and Ramesh Thapar, pronounced on 26th May 1950, set the trend. The freedom of speech and expression guaranteed by Article 19 of the Constitution, it elucidates, is a right that could be restricted only under 19(2), which provides for certain reasonable restrictions. In another case, it was held, liberty of an individual and the protection of fundamental rights are the very essence of the democratic way of life adopted by the Constitution. And it is the privilege and duty of this court to uphold these rights. This court would naturally refuse to subscribe them or curtail them except as provided by the Constitution itself. The second decade of 1960s, the years of anchorage as well as discovery. In 1960, the sanction strength of this court was expanded to 14. The most significant judicial event of 1960s turned on the interpretation of a single word, law, in Article 13 of the Constitution of India. Article 13 provides a law inconsistent with or in derogation of fundamental rights are, to the extent of inconsistency, void. The courts were tasked to interpret whether the expression law used in Article 13 included constitutional amendment. If it did, then whether the chapter on fundamental rights could be rendered immune from amendment. The discussion continued till the 70s until settled in Keshwananda Bharati's case where majority of the 13 judges bench held that the Parliament can amend any provision of the Constitution. However, such amended powers cannot be exercised to abrogate or destroy the basic or fundamental features of the Constitution. 17 and 80s were years of turbulence, leading the way to social justice and equality jurisprudence. Acceptance of public interest litigation diluted the principle of locus standi to actualize the right to access to justice to all citizens, importantly to the marginalized. Justice Krishna Iyer had reasoned that legal technicalities should not become added terror for the underprivileged. Acknowledging this unique socio-economic constraints, this court in S.P. Gupta emphasized that it was necessary to democratize judicial remedies. In Hossain Khatun, this court dealt with the rights of under-trial prisoners, highlighting the right to speedy trial and resulted in release of more than 40,000 under-trial prisoners. Critical issues of juveniles and other prisoners were dealt with by this court in Kardia Pandian's case. In Insulit Batra, the court highlighted the prisoner's right and systematic issues in administration of justice. In D.K. Basu, this court observed that custodial violence strikes at the blow of the rule of law. It issued several directions to be followed in all cases of arrest or detention till suitable provisions were incorporated in the Code of Criminal Procedure. In Joginder Kumar, this court emphasized that a police officer may have the power to arrest, but an arrest should be only made after reasonable satisfaction was reached as to the genuineness of the complaint, to the person's involvement and need to arrest. In Muthu vs. State of Punjab, the mandatory death sentence under Section 303 of the IPC was struck down as unconstitutional. In Indira Gandhi vs. Rajnaran, this court emphasized that judicial review and fair elections were a fundamental part of the Constitution beyond the reach of the amending powers of the legislation. In Bandhua Mukti Morcha, bonded labor was categorized as incompatible with Article 21, which includes protection of health of workers, women and men against abuse. In the initial years, this court had interpreted all fundamental rights as rights working in exclusive silos. The judicial attitude, however, underwent a significant change after the emergency was imposed in 1975. In Maneka Gandhi, this court ruled, attempt of the court should be to expand the reach and ambit of the fundamental rights. Articles 14, 19 and 21 were not mutually exclusive and had to be read together so that the procedure affecting any of the rights had to be just, fair, and right, and not arbitrary, fanciful, or oppressive. 1990s was the era of consolidation and expansion of fundamental rights. 1990 ushered in an era where the Supreme Court not only remained vigilant to protecting human rights, but also stepped in to address legislative and executive gaps. The court adopted an expansive interpretation of fundamental rights, reading them harmoniously with the directive principles of state policy. In Uniconnect Christian, this court held that the right to an education naturally flowed from the right to life recognized under Article 21 of the Constitution. This led to insertion of Article 21A in the Indian Constitution and enactment of the Right to Education Act in 2009. This court has also been at the vanguard for protection and preservation of environments. In its judgment, the court has articulated the concept of sustainable development, the polluter pays principle. It has also applied the public trust doctrine in several cases, highlighting that public has a right to enjoy common resources, with the state being entrusted to guard and maintain these resources. In Vishaka, this court laid down a set of comprehensive guidelines to prevent sexual harassment at work. The guidelines laid down in Vishaka were eventually led to enactment of the legislation after considerable time in 2013. In Indra Sani, a 9-judges bench of this court held that affirmative action is not an exception, but a tool for guaranteeing equality of opportunity. While the Constitution creates a sound center, it also educates a balanced federal structure. It is one of the basic features of a Constitution, and that cannot be abrogated by constitutional amendment. This was the crux what 9 judges of this court had held in S.R. Bommai. S.R. Bommai also has implication for the secular fabric of India. The court inter alia held that secularism is a basic feature of the Constitution. 2000 till today. The 2 decades after the 21st century stand as a testament to the Supreme Court's evolving role in a constitutional framework. No other epic course worldwide navigates such an expansive domain, from personal liberty to environmental issues, from intellectual property rights to privacy to right to information. The evolution began with strengthening of electoral democracy by establishing voters' right for information about candidates as to extension of freedom of expression, which includes the right to impart and receive information. The court dismantled gender stereotypes in employment, rejecting outdated restrictions on women's workplace participation. Digital rights emerged as a new frontier for the constitutional protection. The court struck down vague restrictions on online speech, extending constitutional safeguards to digital spaces. In social economic justice, it broadened affirmative action to include economic criteria, recognizing diverse forms of disadvantage in the modern society. Apart from public law, these court decisions have strengthened India's economic landscape by injecting clarity, efficiency, and fairness, be it in Insolvency and Bankruptcy Court or Arbitration and Conciliation Act. This court has also strived to strengthen alternate dispute resolution mechanism. Public understanding of justice is evolved from pure legal construct into a living force that touches across the lives in the nation. While the court's journey reflects remarkable evolution of right and reach, 3 challenges demand our attention. The first is the weight of areas which continues to delay justice. The second, mounting cost of litigation, which threatens true accessibility. Third, and perhaps most fundamental, justice cannot thrive where and when falsehood is practiced. These challenges mark the next frontier in our pursuit for justice. 75 years after our constitutional journey began, the Supreme Court stands transformed, yet anchored in its foundational mission. This transformation reflects a deeper recognition that justice must be principled and practical. In doing so, it makes the constitutional promise of justice, social, economic, political, a living reality for millions of Indians. Over the 7.5 decades, this court has transformed constitutional promise into reality through its judgments. Jai Hind.
May I have your Lordship's permission to conclude the proceedings of the ceremonial bench?